Oh, yeah. So which links are there?
It's just 2 links.
I don't have my note paper.
Why you need notes?
Are we live?
We are live.
Hi, everybody.
Hi, everyone.
Hi. Welcome, everybody.
15? Oh, they're that's fast. When I looked, it was only 8.
Hi, Marcia. Welcome. Happy Sunday. What a girl look like her mother. Who are you talking? This is Xander. Hope he's not Xander. This is Xander. It's a boy. Xander.
Maybe it's me.
Cute as a button. Xander, you see? Look.
See the people?
You see the people? Who? So where read these comments for me, Xander? Your turn to read the comments. Hi, Devonique. Thank you for joining us.
Hi, Janet.
Hi. Hi, Lisa Marie. Well, I have good news for you today. We have the lawyers will be coming on from Richards and Richards talking about will and divorce. I hope those of you who who need a divorce can get an easy divorce. Right? Very easy divorce. I want to make it simple for you to be able to get that divorce and move on with your life, right? Mm-hmm. Raise your hand if you need to get a divorce. Or you need to write a will. Raise your hand.
Raise your hand.
Anybody yet need to get a divorce?
Yes, Pam. I'm her daughter.
Yes, Pam. Hi, Simone. Happy Sunday. Happy Sunday. Okay, everybody. So you can actually start asking me the questions. We're going to bring on the lawyers maybe in another half hour or so, but we'll take some of your questions first. Thank you so much for joining us and for subscribing to our channel. Those of you who have not yet subscribed, you can probably just do so now. And you can also remember to give us a thumbs up.
Tiff is asking, good afternoon, Miss Claudia. Are you still planning to resign this January?
Resign, retire, retire. Yes, I'm retiring. This is my retirement year, actually. So I'm just doing some wrapping up stuff. So by December, I would have been just gone on to be a Grammy.
Looking forward to that, Xander?
Yes, I'm looking forward to teaching Xander how to run, climb the stairs, backwards, come off his bed, backwards.
You know, he almost turned over this morning.
Almost, not quite there, Xander.
Like he went on his side fully.
Right. So Xander is 3.5 months now. Soon hit 4 months. So I'm the one who will be teaching him how to read, write, how to build buildings.
Oh, he's gonna build buildings?
Yes.
Xander, architect or engineer?
And he's going to draw buildings too. Your mommy can teach you some Chinese. You almost look at the color of the Chinese. Yeah, but this is my retirement year, so I'm doing some wrapping up, hand over to my children, digitizing systems so that it is in their era. I'm a pen and paper person. Everything is pen and paper. I still work with this big diary. Right, but you know, they say, Mom, no, we can't work with that. It has to be digitized. So that's what we're doing now. We're getting everything.
Here's our first question. Good day, ladies and Xander. How does a self-employed person build relationships with the bank? Plan to start depositing to set an amount every month and increase to down payment. Thanks. That's
right.
Q8.
You not only do you need to lodge every single money that you get.
Also, not just the portion that she's putting aside for the deposit.
No. Build a relationship with the bank so that they can see your ins and outs. Self-employed, all income goes to the bank. That's the rough part for self-employed. Because you do a job for somebody, them give you 10,000 cash, and you get that money, then you buy gas, put in your car. It don't go to the bank, right? That's a challenge. Or you stop at Burger King and eat a burger, $1,000 out of it. Now, every single money that you get, and that's a challenge with the self-employed. Because you're collecting cash, it's a challenge, right? But if you want to build a relationship with the bank, every money that you get, you put it in there. You keep a proper check and balance, because they're going to ask you for a cash flow statement, and you're going to need to help your accountant to do that. And the only way to do that is to keep all your receipts, write down all your income that you get, put it in the bank. Whenever you spend money on gas and those things, try and set it up so that you can probably maybe use one of your cards so that you have a record of it. If you go through the toll, try and set up a toll account. Things that you do not regular, you try and set up systems so that at the end of the year now, you will have all of those receipts and your credit cards. So like for us, we do a lot of internet things. So like this thing that we're on, what's it called? Live studio, Restream. Restream, we have to pay for that. Is it monthly? Monthly. So we send that through our credit card. So at the end of the year, we can go through our credit card and see how much money we send to Restream, right? And that's an expense for our business. So you would need to set up the same kinds of systems. When you go to the gas station, get the bill from the pump attendant, the bill, so that you can have it as one of your expenses. Then, at the end of the year, you're going to file your taxes. Now, in Jamaica, we're allowed to self-file. So self-employed can self-file, meaning we're the ones who say we earn $10 for the year, and that our expenses were $5 for the year, and that we made $5 or so. Yes. So that it is that $5. So it is income minus expenditure, or I should say sales minus expenditure, and what is left is your income. That is what the bank is going to use to determine if you can pay a mortgage, right? So you have to have, and they're going to want a cash flow statement from an accountant and all of that. So you've got to keep proper records. And they're going to want about 2 years of that.
2 years.
Yeah. But as I keep saying, self-employed, National Housing Trust is your friend. You want to register, you still have to interface with the tax people. And Tony can help you with that. You need to WhatsApp her to, what's it called?
File your annual returns.
File your annual returns. There are 2 forms that need to be completed, SO4, SO4A. Well, that much I know. But she'll help you to complete those, get you onto the tax portal if you're not on it yet. And you go to the tax office and you pay your money. And then 1 year you qualify. Now, you have to pay the income tax. If you're above the threshold, you would pay the income tax. So if you earn 2 million income, the threshold is 1.5. So you only pay income tax on 500. 2 million minus 1.5, right? If you're below the threshold of 1.5 per year, meaning that you never earn more than 1.5. So Xander, just keep going on. You never earn more than 1.5. So therefore, you will not pay any income tax. However, you will pay 3% to the National Housing Trust. You'll pay 2.25 to education tax. That's what it's called. Yes. And you will pay, the other one is your NIS. And where is that now? 5-point-something percent.
2.5 or 3.5?
It's 5-point-something percent. But it's also capped. So if you earn over a certain amount, the maximum, it is capped. We don't know what it is right now, but it's capped at a certain amount, right? But up to a certain amount, you would pay the 5 point whatever. And then when you reach a cap, like let's just say the cap is 80,000, and I'm saying this off the top of my head. I know one time it was 75,000. I don't know if they raised it, but
no, it was raised.
It was raised. We just don't remember what it is now. It's taxier now, but we're getting in the groove of getting the new numbers and so on. But you would have paid when you work out the 5 point. Let us say it's 5.5%. When you work out that 5.5% of your income, if it is less than the 80,000, for argument's sake, you would only pay maximum. You pay up to the 80,000. If it's more than the 80,000, you pay a maximum of 80,000. Don't quote me on the 80,000, everybody. call the NIS office and get the right numbers, right? Where can we find the link for the Zoom session?
I'll send that later on in the session.
Good day, ladies. Hold on. Okay, so we answered that question about self-employed.
Right. Chris says, oh boy, if you're returned, who can I trust?
Tonian is here.
We're still working.
Tonian is here. I'm behind the scenes.
Are you gonna really be behind the scenes though? Because who's gonna do your videos? Who's gonna say welcome, welcome, welcome?
Yes, Zans.
It's still gonna be on YouTube.
Zans will do it. I should have retired from when I was 50. I said I was going off at 50. I didn't go off at 50.
Mm-hmm.
And now it's 50. I'm at 55.
But what happened if you couldn't go off? Because that's when we started our YouTube channel, and then
you will never get into the groove fully and
right.
all kind of stuff going on. So the thing is a transition, guys. Remember, we talk about succession planning. We talk about making sure that your children can transition and take over so that you can pull out, you can go and enjoy yourself, right? So just remember, those of you with children, start to acclimatize them to doing certain things like how you pay the JPS bill, how you pay the water bill, managing your budget, those kind of things. You need to start to get them into that activity right now.
DJ is saying, hi Claudia, I called you a couple times, but I didn't get any answer. I'm selling a home in Jamaica.
You are DJ. DJ, send us a WhatsApp. You can shoot me on WhatsApp now, 292-6776. It will come to the top of our phone. Just remind me that is DJ.
All right.
Remind me, DJ, that is DJ.
Sima wants to know, if you're purchasing in a new development, do you need the services of a real estate agent? Also, what's the contact information for the real estate lawyer you mentioned before?
That would be Richards and Richards.
And they'll be here
They're
shortly.
coming on shortly. Do I know the number out of my head? I don't think so. Mrs. Richards, can you just post a number, please, for the office? For your office, Richards and Richards.
In the comments.
In the comments. Type it in the comments, please. All right. So there was a question before that. If you need all right. So some developments use real estate agents to sell.
Mm-hmm.
So like we're selling Beleka. Beleka is using real estate agents to sell. In that case, you go through the real estate agent. Some developers do not use real estate agents. Some of them that I can think of, like Gore developers, you don't use real estate agents. New Era Homes, Chemtech, Wicon.
Mm-hmm.
Well, sometimes Wicon will use real estate agents. For the last couple of offerings, I did use agents. Mm-hmm. But you don't need, if they're using an agent to sell, then yes, you would go through the real estate agent, yes. Because they would be the real estate agents would be the marketing team.
And chances are that they're using the agents to collect all the necessary
information from you, right? Hi, Claudia and Tony. Xander is too sweet. Yes, isn't he? I end up babysitting him. He's a nice kid. He doesn't give any trouble at all. Are there 1 bedrooms or 2 bedrooms apartments available at Bayfront? Yes, there are. Still have on each floor, I do believe. The higher up on the floors, the more expensive, but yes, we do have. And Bayfront I mean, the place is so nice.
It is.
it literally, guys, it's like you're going to be living. Those of you who get to live there, it's like living in a hotel.
It is. It's like when you said Trump Towers. You're going to
be living in something like that.
Yeah, it's nice.
I mean,
concierge service.
Yes, everything is there. I mean, you have your full gym. I mean, big gym, swimming pool. We'll step out to the beach, just like that. So you literally, don't walk through the lobby in your bikini. But you're literally stepping from the lobby into the sea. I mean, it's going to be so nice, though. It's really going to be one of those services that just lift the value in Portmore. Yeah. So those of you who haven't yet gotten into Portmore, I mean, when Portmore was around, I was trying to buy, I couldn't afford it. I had to go to Spanish Town.
Mm-hmm. That was in the 80s.
That was in the 80s. still that way today. So Spanish Town is still cheaper than Portmore.
And it's funny, but you get more house in Spanish Town, but it's just cheaper.
It's cheaper. You get more land too.
Yeah.
I guess because Portmore is a city, guys. Right? It's a city. You have to say it is a city, just like Montego Bay and St. Andrew.
I know you literally could live in Portmore and never go to Kingston or anywhere else because everything
is there now. Everything is in Portmore. Everything that is in St. Andrew, people is in. No, I shouldn't say that. What? You know what they don't have?
What?
They don't have a hospital. And they did have some plans to put a hospital there. I don't know what happened though. Yeah. But that's about the only thing
they don't have.
I would say that they don't have, but they do have everything else. You have another question? All right, so I need to also say that there was a young man, he's probably listening, I hope he's listening, who reached out to me in December. He wanted me to assist him and his family in building a bathroom. Now, he did send me a video. If you're listening, I need you to send me back the video because we can't find the contact, the video. You didn't give me a name or anything. You probably did, but I didn't save it. Mm-hmm. And now I'm not able to find it, and I want to reach back out and see how best I can help you to accomplish the bathroom, right?
Right.
So reach back out to me, please. That young man was about maybe could have been more about 12.
12.
Yeah, I think. So
or
if
his mom or any of his friends that's
listening, or who is on the channel. I will know it's you because of the video that you said, because I did watch the video. So what you do, send me back the video and give me your name, right? So that I can know that it is you. Any more questions?
Yeah. Let's see. Cheryl Johnson, she says, good afternoon, Miss Claudia. I'm looking for a lot to build on, looking for St. Andrew area.
Okay. Hi, Cheryl. Can WhatsApp us? But you need about 10 million up. Mm-hmm. You're looking in St.
I was looking for something in Chancery Hall for a client today, and the cheapest thing there was 18 million.
What am I saying? So 10 million is where? Plantation Heights.
Maybe.
Or not Stony Hill.
What about Belvedere?
Not Belvedere.
Not Belvedere.
Not Red Hills. Maybe Cooper's Hill up in the top.
Cooper's Hill. Maybe.
Yeah.
Okay, here's someone's asking. JM says, question, is there any residential lots in St. Thomas, closer to Kingston?
That would be Bull Bay.
But Bull Bay lots are like gold because they come up, they disappear.
Yeah, Bull Bay is gold now because of the highway coming. But we don't have anything right now. Have they added a pool to the Jamaica?
No.
3D villas.
Says, I noticed they have added a pool to the Jamaica 3D visual. Would the board permit this if someone wants to build a pool in their backyard?
Sure. Once the space is there. It's not a big pool though, you know. It looks big, but it's not a big pool.
No, it's a little
wading pool. Yeah.
To do some like resistance swimming.
Yeah. It's not a big pool, guys. But that is just the artist's impression, right?
Right.
So he's showing you what you can
do with that backyard. Cora asking, if I get a mortgage in Jamaica, overseas residence, does that allow me to get other Jamaica credit, i.e. credit card, auto loan? I'm gonna need a car after buying my house.
Yes, you can. Once your salary can take it. The more whichever. So all the mortgage companies give car loans now. Jamaica National, Victoria Mutual.
Right, so chances are if you get a loan already for the house with, let's say, Jamaica National, then you can probably get an auto loan from them as well.
Yeah, just depends on your income. Your debt service ratio.
Jacelyn. Jacelyn says, I have not been on your show for a long time. Well, is your grandbaby? Yes, that's her grandbaby.
Yes, this is one of them. Hoping to get some more.
You can manage?
Want to fill up the house. Need at least 10. 10. Nuisance.
Sham Crazy TV wants to know, do you have any land selling in the 3 to 4 million range? Depends on where. You can get that where. Clarendon, maybe Mandeville.
Maybe Mandeville, not Mandeville, Clarendon.
Right, or Manchester, wider Manchester.
Yeah, in the rural parts of Manchester.
Can get it in St. Anne, Brownstown section.
We have a Pembroke estate coming out this week, 4.5 million.
4.5.
You need a cheap land in somewhere in St. Catherine. That's Linstead, Bogwalk. Can't get cheap land there. With will and trust.
Ron Lewis wants to know, good evening, can I get a house, 2 to 3 bedroom in the Caribbean estate, Portmore for 18 million? You could 3 years ago.
Those have gone over 20 now.
Yeah.
So you might have to borrow it or save.
Or save, yeah.
You want to scroll down? Oh, everybody, I'm supposed to be losing weight.
How's that going, Mom?
Tony, tell him about our subscriber. So I've been saying that if I lose this weight and I get down to 150, I'm buying myself what's it called? GLA. It's a GLA 180 Mercedes Benz.
Right.
Look at it, what it looks like, guys. Little cute, little baby car. So one day we were reading the comments. And one of the subscribers said, Miss Davis, if you lose the weight, I'll buy you the Benz. What's his name, Tony?
SK Samuels? FK Samuels.
FK Samuels.
I believe that's the name.
Anybody knows who is FK Samuels? He's probably listening now. FK Samuels, I tell you, I'm taking on your challenge, you know. So if I lose the weight, you buy me the GLA Mercedes Benz. I only want a 2018. The only stipulation is that it have Bluetooth, right? Because I have to go hands-free. I can't be talking down that phone here, so while driving, right? So, Mr. Samuels or Miss Samuels or Mrs. Samuels, remember, you know. Oh.
So how much weight you have to lose to get that Benz?
I need to disclose my weight. How do we disclose our weight on YouTube Live? I know I'm over 200.
You have to stand on a scale.
I know I'm over 200. All right, so next week we'll do it. So guys, I think I'm at 205 now. So we'll do a live weigh-in next week.
So what you planning to do this week to lose some weight for next week?
Very good question. I'm gonna figure it out yet.
You could go walking with me in the morning.
No way. Not going out, Zans. We're not going in no cold for go walk. Yeah, you know what I mean? No, I have to find another way. Find another way. All right, you have another question?
All right. Let's see.
Thanks, Tony, for the tips. I need a cheap land. Would a will and a trust be classified as the same? All right, we're going to ask the lawyers when they come on. They're coming on shortly. So stand by HAV, Hey Jamaica TV. What's the name?
Hajaman.
Hajaman TV.
Hajaman Dan.
No, that's not Hajaman asking that, is it? No, that's Chris Hill asking that question.
Oh, Chris is asking that.
Would a will and a trust be classified as the same thing? All right, so when the lawyers come on, they can make that distinction for you.
Okay, Hajaman is saying, good evening, ladies. Thanks once again, Tony, and for all the tips with my channel. I'm waiting for a land title. Would it be better to write a will or just add the children's name to the title?
You can add your children's name to your title. If they're under 18, then you're going to need to add a clause that will allow you to can transact business with the title just the same, just in case you decide to sell it. So let us say I have a piece of land and I want to add Xander's name. Xander is under 18, so Xander cannot do any business. He can't sign anything or anything, right? All him can do is yarn.
Want to sleep.
Want to sleep. Xander, mom eating already now. You have to wait. So Xander can't do any signing. So, but Xander's name is on the title. So there has to be a clause there that says I, Claudia Davis, can still, and the lawyers will come on. We need to write it down. Although we're not doing conveyancing today, but there's a clause that is added to the title to to say that yes, you can mortgage, you can sell, you can whatever, right?
Right.
It's two things. Either you do the will or you add the names now. If the children are over 18, you can add the names because everybody can sign.
Mm-hmm.
Also, the children are over 18. Chances are they're working. So I would say let them pay for that transfer.
Definitely.
Right? Because they're getting a benefit. They're getting a property. Their name is on the title, not just on the birth certificate now, but on the title. And you're doing very good for them. So I would say if you're going to add children over 18 and them have a job and all of that, let them hug up the cost to add the name. That way, Rach, then there's asleep. You want to put him in his bed? That way, if anything should happen to you, then the children would now get it. And I personally prefer for my children to add it joint tenants. That way they would get it automatic and they wouldn't need to probate and will and all of that for me, right? Mm-hmm. So that's what I would do. But it depends, as I say, on the age of the child and all of that.
M.E. San says, could you recommend a trusted lawyer? We have one coming up in a few minutes. One
is coming up right now in a few minutes. Standing by. Richards and Richards, standing by. They're going to be talking to you today about will and divorce. I know divorce can be contentious, guys, but you have to try and work it out, right? Try and work it out.
Work on the divorce?
Yeah, work together. Don't look at the problems in front of you. Mm-hmm. That poem by that young lady, what's her name? The young lady who did the inaugural poem, Since Week. I was at home when she did the poem. I was babysitting Zan's at home and doing some taxes. And when she came on, I was listening to the whole thing. When she came on, I was blown away. There's a part in it where she says something like, don't look at what the troubles in front of you, but look at who is in front of you.
Oh.
So profound. I think I actually sent it to either you or Rachel.
I think when persons are getting a divorce, you should say, what's the quickest way to get out of this marriage?
The quickest way?
Yeah.
Well, just as fast as you're going.
People always want to fight for this and fight for that. But if you think of it, that's the quickest way to get out.
Yes, and
you solve the problems quicker.
Yes, and cooperate. The lawyers are here and they'll tell you there is no point. I'll tell you, I know of a case. Look at it for me. I think. Oh yes, I found it. I sent it to Rachel. One of the lines says, "We lift our gazes not to what stands between us, but what stands before us. We close the divide because we know to put our future first. We must first put our differences aside. We lay down our arms so we can reach out our arms to one another. We seek harm to none and harmony for all." What was her name?
You have to look it up another time. I need to
look it. Somebody please tell me. Somebody must have been watching and was there when she was giving the speech. Mm-hmm. Is it such a beautiful young lady? Her name is slipping.
All right, here's another question.
Look for her name.
Melissa wants to know, do you think I should go ahead and buy a house for 2.9 million that have 2 breaches that will cost around 400,000 to fix, and it also needs a lot of repair?
Where's she getting a house for 2.9 million?
I'm not sure.
Amanda Gorman is her name, everybody. Amanda Gorman. If you didn't hear the poem that she read at the USA inauguration speech, I implore you to Google it, listen to her speech, live by her words, and you can't go wrong. 2.9 million, 2 breaches, 400,000 to fix. I need a lot of repairs. Depends on where the house is. Mm-hmm. So 400 added to that, so that house is 3.3.
No, but that's just to fix
what are
the
the
breach.
repairs? What is going to be the value when you fix it under the breach? Does correcting a breach mean you're hitting down something, or does it mean you're just fixing the covenant and title? What is correcting a breach mean?
Yeah, Melissa, let us know. We need some more details.
And where is the house? 2.9 million. Where is that house? With regards to obtaining mortgage, which properties show for?
Chris wants to know, with regards to obtaining mortgage, which properties allow for American bank financing, since the interest rate seems to be much lower than NCB or JN?
What's the question?
I guess they want to know which American bank allows you to get a mortgage.
Oh, you
in
mean
Jamaica?
you want to know which bank in America will give you a mortgage to buy a house in Jamaica? That's what you want to know? None. What you will do is either take an equity from your home, or if you can get a demand loan from the bank overseas, and then you just use that money to buy the house here, or you take a home equity line of credit from using your home as a collateral up there, and then you use that money and buy the house out here.
Oh, okay. All right, it's 3:30 now.
All right, Rachel, can you? Rachel, Rachel's still eating. We need a babysitter for you on Sundays. He's sleeping. Can I put him in his playpen?
Is there a sheet in there? No?
Oh, set it up for him so you can get him. All right, so what's the other question? We're going to bring on the lawyers now, we think.
Yeah.
All right. So, Dennis and Shereen Richards. They're the ones who are partners at Richards and Richards. Husband and wife team, everybody. Working together. I met this fabulous couple at the stamp office one day.
The stamp office?
The stamp office. I was in there doing something for a client, and of course they were in there doing something for a client. I was very surprised to see lawyers in the stamp office. You know, I said to myself, hold on, because I heard them talking. That's when I realized that they were lawyers. And I said to myself, but these guys are so hands-on, you know, to be at the stamp office, getting the thing done for their clients. And then in listening to them, I said, wow, they're so down to earth, everybody. Shereen and Dennis Richards. So, Dennis's practice focuses on business, property, and personal wealth matters, right? So Dennis will be presenting on will and divorce, right? He has been the Chief Executive Officer of Veritas Trust and Corporate Services since 2016. So Veritas functions as agents or attorneys for the administration of estates, as well as corporate trustees. In addition, the company acts as trustees for a range of trusts and acts as corporate secretary for a number of Jamaica-based corporations. Shereen Richards heads the family, property, and estate practices at the law firm, right? So Mrs. Richards, she has a 23-year career in banking, pensions, and insurance before transitioning to law, and was a tutor in public law and English legal systems between 2007 and 2010. Shereen, hold on, you probably teach me a Caribbean school, man. I didn't know. All right, so ladies and gentlemen, I want to welcome Mr. and Mrs. Richards. Dennis.
Hi. Hello, everyone. Hi. Very good to be here.
All right, everybody give us a thumbs up if you can hear Mr. Richards. If you can see Mr. Richards. Somebody tell me retirement age is 65. Don't make them brainwash you. I need a thumbs up, everybody, so that we can proceed. Awesome. Give me a thumbs up. Awesome. Want to make sure that we are not losing anybody. Everybody can hear us. Are you getting the thumbs up?
Yes, they're coming in.
Oh, thumbs up. Thank you. Thank you. All right, the floor is yours now, Mr. Richards.
Afternoon, everyone.
Hi, everybody.
I am going to go through a PowerPoint slide. It won't take long, and then afterwards we can just go through your questions as you ask them. So I'm going to share my screen in a few seconds.
All right, so we will take back the real estate questions after we will also be giving you a link so that you can contact Richards and Richards directly. So if you're interested in wills or divorce, I'm going to give you a link so you can fill in the information and contact them directly. So could you recommend a trusted lawyer? Yes, Richards and Richards. Did they put in the phone number in the link?
I'm not sure.
Is everybody seeing the slide? I'm not sure.
Thumbs up, everybody.
Yeah, you're seeing it.
Yes, you can proceed.
All right.
Awesome, beautiful.
All right. Before we even start looking at the will, we want to explore why you need to do a will. The basic thing is you want to make sure that when you pass, and you're going to pass, what you have, what you work hard for, it goes to who you want it to go, and it goes how you want it to go. When you don't leave a will, your estate, which is everything that you own, your estate, how it passes is governed by law, not necessarily how you want it to go. So I'll give you an example, which is a real example. I remember a client came to me. She was married to this gentleman for 22 years, but she had moved out of the house about 18 years before. And basically what happened is that she started life with somebody else, but she never went ahead and got divorced. So all throughout the 18 years with this other gentleman, she was still married to the previous one. What would happen is if she passes, her estate and everything, half of it would essentially go to the former person who was really still her husband, which that is not how she would want her things to go. So what you want to do, if you want your assets to pass how you want it to go and at the lowest possible cost, the best way is to do your own will. Now, that's the basic reason why you need a will. You need a will to settle your estate quickly and at the lowest possible
and
cost.
To speak for you, yeah.
And a will is a document which allows an individual, they call him a testator. It allows a testator to pass their assets after their death. So a will doesn't have any effect while you're alive.
Right.
It allows you to say to whomever is in charge after you die, this is how I want to pass my assets. So it's a simple document, but it has to follow a certain procedure for it to be effective. The first step is to choose the individuals who are going to actually settle your estate.
Step into your shoes.
Those persons essentially step into your shoes once you pass.
Right.
They are the ones who are going to normally be responsible for dealing with the funeral and those things. Doesn't have to be them, but they are definitely ones who will settle your estate. And they're called executors. Now, because executors do so much work, you have to get responsible people. It has to be somebody, it's not necessarily a closest friend. It has to be somebody who you know is responsible and will go about and get things done. It is also, since you expect this person to wrap up your estate, it's also a good idea for you to make sure that they are normally younger than you are. Not saying that younger persons will outlive you, but that's how things normally go.
Right.
So you don't necessarily want your executors to be older than you are, because chances are they may pass before you do. And another tip on choosing your executors, try to get more than one. You don't want a whole heap of them, but you don't want to have one. So two is normally a good compromise. Oftentimes when we're doing wills, and the truth is, in the whole heap of wills that I've done, very few, I've only done 2 wills for men. It appears that men don't die. It's mostly women that I do. It's mostly women come in and say, I'd like to have a will done. I don't know why, but for some reason, they're the ones who ask for wills. I'm suggesting that we consider doing it. And this is one thing I always say. Persons come to me, they say, I don't have any money, so I can't do a will. And I always say to them, if you have children, that is enough reason to do a will. If those children are minors
or
they have disabilities, that is sufficient reason to do a will. And what you want to do is to appoint what is called a testamentary guardian. That is a person who you will name in your will to say, if I go, this is a person who steps into my shoes as that child's guardian. So we have done wills where the only thing in the will is to appoint the testamentary guardian.
Yeah.
Person have no house, no car, no nothing, but they have children, minor children. And
apologies.
That is a good enough reason to do a will. Now, after you have chosen your executor and your testamentary guardian, the rest of the will is simple. It is really a matter of you writing down all that you have to give, and then now beside each gift, you write down who gets the gift. And there is a very important word of caution. You have to describe the gift clearly. So sometimes persons will say, I pass my Mercedes-Benz to Claudia, for example. You can't do that. You have to say, I pass my, for argument's sake, my 2018 GLA Mercedes-Benz, the black one, to Claudia. That is a better gift because it's clear, you can identify it, and you wouldn't just say Claudia, you'd have to say Claudia Davis, so we know which Claudia. So one of the problems we have with wills is when you're doing the gift, identify the gift clearly. If it's a house, you give the address. If you know the volume number, the
folio, the title reference,
include that. And then the who. You can't just say, I leave it to my son.
Which son?
Dangerous. Because especially with guys, sometimes you have more sons than you know. And that creates no real thing. It creates some problems. You have to identify the person who gets the gift by their names, and if you have their TRN or their social security, use that. Because one of the most contentious parts of our practice is settling estates. If you want to see the worst in people, that is the area of the practice you want to see. The teeth come out. All right.
Claudia probably call it dead left.
Now, when you're doing the will, the first thing you have to prove is that the person doing the will has capacity, meaning they're not insane. Sometimes people come to us and say, my grandmother wants to do her will. I say, yeah? They say, yes, she's at the nursing home. She has dementia, but she come and go. We always decline that because we are not sure if when the person is doing the will, they are here or they are there. We don't know where the mind is. A person who has dementia is not normally able to do a proper will. That person has to be of sound mind. And also, they have to be above 18. Another thing to look out for is undue influence. Meaning, we get a lot of cases where certain professionals like nurses are the ones who will call us to say somebody wants to do their will. And then they stand over the person while they're doing the will. You will notice in those, we got a will 6 or 7 years ago. The lady left her house, 2 houses, her car, her bank account to her nurse and the driver. She left out her husband and her 3 children. And essentially, it was undue influence. These persons who were caring for her in her latter stages pretty much pressured her to exclude everybody else and put them in only. The court looks out for that. I should say this, when somebody dies, the will doesn't kick into force automatically. You have to file it in the Supreme Court or in the one of the courts in Jamaica, depending on the value of the will, the assets in the will, either the parish court or the Supreme Court. But normally, it's the Supreme Court. And that process is called proving or probate. So the will don't kick in normally. The will is sent to the court, and the registrar at the court scrutinizes it. So what we're saying to you, to make sure it passes scrutiny, you have to make sure things are done properly.
From the get-go.
Right, and one of the things they look for is undue influence. Another thing now is so-called attestation, which is really just witnessing the will.
Right. In Jamaica.
When you do a will, the law says 2 persons must witness when you sign the will. Those persons must witness you signing the will at the same time. Otherwise, the will is not good. So you can't let John Brown witness your signing and then call Paul to witness it.
No.
It has to be done simultaneously.
Present at the same time you are signing.
Yes. The Wills Act says it must be done in the joint presence of the witnesses.
Right.
Now, your witnesses, you have to choose them carefully because your witnesses cannot benefit in the will. Your executors can benefit, but your witnesses can't benefit under the will. And the main reason for that is that the court is afraid of undue influence. Another thing to remember is that the spouse of the witnesses can't benefit either. Now, here's what happens. If the witness is mentioned in the will as a beneficiary, the court is not going to view the will as being bad. What they're going to do is consider it a good will, but the beneficiary can't get the gift. So you have to be careful. If you want somebody to benefit in the will, do not let them witness it. Another thing we find happening, and the court hates it, is when you have a whole heap of witnesses. If you have more than 2 witnesses, the court gets suspicious. They call it superfluous witnessing.
Excessive. Yes.
You don't want to have 3 or 4, 5 people who witness the one will. 2 is good. 2 is what the law requires, just use 2. All right. Now, basically, once you sign the will and in the presence of the 2 witnesses and they sign and date it, that's it. The will is a good will. It doesn't have to be done by anybody in particular. It doesn't have, you can buy the store-bought will. Many of the bookstores in Jamaica, pharmacies sell them. We didn't like them initially, the store-bought wills, because they were badly done. But in recent times, we have found them, they've been updated and they're much better. The major problem we had is there is an attorney will do a will with what is called a rest and residue clause. Let me tell you what that is. It is a clause that says all my estate, all the remainder of my estate, wherever it is and however it is, I pass to so and so. What that clause does is to realize that oftentimes you own things that you don't know that you own. I did a will in 2012 or 11 of a lady who her grandmother left her 4 properties.
Oh, she came to us.
Yes.
Right.
And all 4 properties were sold before the grandmother died. So she thought that she didn't have anything under the will. When the will was probated, it was found that she owned 34 properties that were not mentioned in the will. However, the grandmother had a rest and residue clause that says all my estate, wherever they may be and however they may be, I leave to my granddaughter such and such. The lady ended up owning beachfront property in the grave. She even got £300,000 lottery that the grandmother won in the UK. Yeah. The grandmother didn't even know she won the lottery at the time. Wow. So you always want to make sure you get, if you're not going to use an attorney, make sure you get somebody who knows what they're doing so that you don't leave out those clauses. Right. Now, once you have a proper will, sometimes you may want, well, first thing, you want to store it properly. You don't want to store your will, say, in the kitchen or in a garage, because the courts sometimes believe that you are trying to revoke the will.
It might be interpreted as such.
Yes. You see, one of the things you'll notice at the start of every will, it says, this is my last will and testament, and all my previous wills I revoke. Now, once you do a will, it ordinarily revokes all your previous wills. However, sometimes you will have your first will and your second will being read together because maybe your first will mentions a particular property that the second will didn't mention. What you don't want is to not properly revoke the previous wills when you do subsequent wills, because we recommend, since we're always growing and improving in life, as you acquire assets, as your life changes, you would want to update your will. No, I mentioned the remainder clause a while ago. That's that clause
Same, rest and residue clause.
Captures everything. You want to make sure it's in that. No. Jamaicans store the important assets like in the dresser drawer and them kind of yeah, that's where people would look for a will, and those are the kinds of places you'd want to store the will. And I mentioned previously, you want to avoid the presumption that you're revoking your will. So when you're trying to hide it, don't put it in the fowl coop outside, because the chicken coop is a safe place. The people that will find it. But if somebody does find it, the presumption is that you're trying
to throw it
away. So, and it has, I'm talking case law, it has happened. So try not to do that. Just a tip we'd like to recommend, you don't have to do it, but it's a good practice to reduce contention. There is a government agency called the Islands Records Offices, right beside the Registrar General Department.
Where you get your birth certificates, etc.
It's not the same entity, but they are side by side. You can record your will. In other words, you can have a copy there. So when the person dies and you get that copy from the Island Record Office, it will show what the actual will looks like, because sometimes people find your will and then tear out pages, them
try to replace,
them modify things, right. But when you have a copy by the Islands Records Office, it is clear what the will should look like, what should be in it. A good tip to you see, if you're doing your will on a computer, you know you can have Microsoft Word have like the page numbering. Don't just do like page 1 or page 2 or so. You know, you can have it say page 1 of 2, page 3 of 4 or so. That's a good practice, but definitely number the pages. Because we have seen cases where people just rip out an entire page that gives a gift to somebody that they don't like. Now, there are some peculiar things to wills that we've seen in Jamaica. I've never really practiced law anywhere else, so I don't know if it happens anywhere else, but trust me. I've seen a will about 5 years ago. The person said, the upstairs bedroom, I give to Angela. I give the kitchen to Peter. You can't give away rooms in your house. Don't worry. You have to, if you want your 5 children to have a share in the house, you have to give the 5 of them a share in the whole house. You can't give one the bedroom and another one the downstairs bed. Don't worry that way. So that's pretty much how a will is done and what you need to get it done. Our wills are governed by an old statute out of England called the Wills Act, 1837. It's very, very old. And I'm going to give you about 3 or 4 general things to remember about wills. 1, if you have done a will and you get married, the will is automatically invalid. The law assumes that somebody who gets married has it as their intention to include their spouse in their will. So if you had a will that you drew up last year and then you get married today, that will is of no use to you unless it can be shown that you did over the will to include your fiancé. Then the law will say, yes, it was a will done in contemplation of marriage, but otherwise you have to do it over. Another thing to remember, under Jamaican law, the will must be in writing, ordinarily. There's only one exception to it. I know a lot of US states have the exception, but we don't. it has to be in writing. The only time they allow it to not be in writing is if the person who is doing the oral will was in war, in battle, and dying. So if you are mortally wounded in a battle, you can do an oral will in Jamaica, but that's the only. And since we haven't had a full-blown war for a while, all our wills have to be in writing. The last thing I want to leave it with a will is if you don't do a will. If you don't do a will, what you'll find happening, there is an equally old law called the Intestate, Estate, Trust and Property Charges Act. Very long name, but what it says is, if you have an asset and you die, and you only leave a spouse, your spouse gets the entire estate. If you leave a spouse and children, spouse gets half, and the other half is divided among the children. And it goes on and on down dealing with if you don't have children and so forth. But here's the danger. Very often, and we've seen it a number of times, the person don't have any spouse, don't have any children. What they may have is cousins. The law doesn't deal with cousins. It doesn't regard them as being able to share in the will, in the estate automatically. I don't believe it deals with nieces and nephews either. And that's common, where a person may die not having children, but they have a lot of nieces and nephews. Those nieces and nephews are not able to share in the estate. So it may be an individual whose older siblings left children. Those older siblings have passed. This person's assets will go to the government. They call it bona vacantia. You don't want to work hard and then leave it to the government. The government is not broke. They don't need your assets. So we recommend that you do a will. But that's it. If you have any questions, I'd be happy to answer them.
If I may. Hi again, everybody. There were a couple of questions that I was following. I believe Akeem Salmon asked, since he's married, if it is possible that shares that he owns in companies, etc., if it would automatically pass to his wife. Again, based on the presentation Mr. Richards just concluded, you would appreciate that if you want to have a say after you've passed, it is best to put that your last wishes in a will, even if it is just if it's to your wife, so it won't be automatic.
I said this to you though, sir. If you remember, when you buy shares, you're going to get a share certificate. The share certificate is kept by the registrar for that company. They're going to have a document in-house that lists each share number and the person that owns it. They won't automatically transfer the shares that you hold to your spouse if you pass before her. You have to do a will. And one of the saddest things, I did an estate years ago where my client's father died 83. They didn't leave a will. He had no idea. But when we did our research, he ended up owning 300,000 Scotiabank shares. He had way more money than he thought he knew. Now, if there was a will, he would have known this. He wouldn't have had to go through most of his childhood as broke as he did, not knowing that he had so many hundreds of thousands of Scotiabank shares.
All right, so another question was an executor who didn't know that they were an executor appointed in a will until sometime after testator, that's the person making the will, had passed. Rightfully, an executor being named, a lot of persons, we Jamaicans want to keep things private, but executors rightfully should know that they are being named in a will so that they can act and act quickly for a number of reasons. You talk about, an estate that is not handled within a certain period that will attract interest on the government fees and taxes and so on. So, but if somebody's aware that they're an executor, as soon as the testator dies, they would step into their shoes, so to speak, and start to act in wrapping up the estate. So it shouldn't be a surprise to persons who are named. But I understand that we are sometimes cautious as to telling people our business and so on. That's the particular business that somebody should know that they're being named.
I want to say this too. There's something called the executor's year.
Right.
The executor's year is 12 months immediately after the person dies. No, we normally, what the law says is give the person that year to sort themselves out. Maybe they are grieving. So in that period, no interest runs on, because you pay death taxes, no insurance. In that period, you can't take an executor to force them to settle their estate. Now, to answer, because I think this is where you're going, if the executor doesn't know that they are in the will and the beneficiary wants to get the will settled, the beneficiary can take the executor to court to force them to act or to remove them and to let somebody else act. So it's sad that they didn't know, but because it's a lot of work. But an executor earns from the estate, an executor is entitled to 6% of the cash passing through the estate. So it's not free work. They actually earn if cash passes through the estate.
All right. So there's another question. M. Sands, if you're still around, you were saying if you hold your property with your children, if you need a will. Well, it depends on, you can hold, in Jamaica, you can hold a property one of two ways. Once it's held by two or more persons. That's as joint tenants and as tenants in common. Now, as tenants in common, everybody has a distinct share. So you either hold it 30, 33, 50, 50, you name it. Once you have a share that is identified up front, you can put your share in a will. If it is, and you want to leave it to your children, put that as your interest passing to them, even though their names are on it. They have their distinct share, you have yours, so you'd have to leave it. If it's held as joint tenants, then unfortunately you can't leave property held as joint tenants in a will, because there's something that takes course once you die. It's called the right of survivorship. So there is no distinct share. Everybody holds it 100% and they hold it together. So what happens is once one of the joint tenants die, then the person who survived holds it 100% on their own. So it depends on how you're holding that property with your children.
Another thing too, is it M. Sands? You had asked about how a spouse is defined in Jamaica. It's a very, very good question, and I'm going to answer it for two reasons why I want us to look at it quickly. In Jamaica, it includes common law spouse, single man, single woman living together as man and woman for over 4 years. That for over 5 years, that's a spouse also. I want to mention it because we have peculiarity in our law. We're not the only country, but many countries have it. And what it says is this: even though you have the freedom to put things in your will how you want it to go in your will, the law requires you to take care of your dependents in your will. So if you have a spouse who relies on you,
we're not sure. We're not sure if everybody's hearing, because we're getting comments are being made that you're not hearing us properly. Are we speaking too fast?
I think there's a break in the connection.
Shereen, we're trying to. I think there's a break. We're having some spotty internet signal. We recognized it.
Okay.
We can probably try and refresh. Everyone just hold a moment.
We're going to try and refresh.
All right.
Can you refresh without disconnecting?
We don't want to lose anybody.
All right. So if we get disconnected, everybody, you can just come back on. We're going to try and refresh.
All right.
But we noticed.
All right. Go ahead.
Okay.
Go ahead.
All right. So what I was saying is, we have a law that says you have to take care of the people who rely on you in your will. So if you're married and your spouse relies on you for about maintenance. You cannot leave them out of your will. If you have minor children or children that are disabled, you have to provide for them in your will. If you don't, those people can challenge your will, or their representatives can challenge your will and force your assets to be distributed to them that takes care of them. So when you're doing your will, if you have children under 18, children in school under 23 years, or children who have disabilities that will affect them for the rest of their lives, you must include them in your will. If you are divorced and you have a court order that requires you to pay maintenance to your spouse for a certain period, your will must speak to it, because the law is not going to allow you to escape your responsibilities even though you have a will. So I'm happy you asked a question about the spouse. To answer the question about Jamaicans dying in battle in Afghanistan, I didn't think about it, but yes, I don't recall the Wills Act stipulating that they have to be in Jamaica when they die. What it requires is that they are in battle and they died in battle on oral will.
Right. We might miss a couple of the questions, but as we pick up, we'll go along. Claudia's Mr. Jones asks a question. My father died without a will, meaning that he died intestate, and he died leaving 8 children, but only one lived with him at the time of his death. If everybody's entitled under the Interstate and Estate Property Charges Act that governs estates that are left by persons who die intestate, all the children will benefit. All of them, once there is proof positive, and it's usually by way of their birth certificate being very clear that Mr. Jones was their father, Mr. Brown was their father, they're all entitled. I know why the question came up, one lived with him, is because typically in Jamaica, we believe that we are entitled to it because we are there, and we looked after Papa when he was sick and nobody else cared and whatever. But that does not exclude the others who are not.
You know what we're finding very common too in situations like that? Persons come to us to settle estates, and they say, you know, my father died and I want to settle his estate, and they have absolutely no proof that that person is your father, because the father's name must be on their birth certificate. We say it until we're weak. Tie up those. Ordinarily, when we're doing presentations and wills, it's a 1-hour presentation. So we left out a lot of things today.
Right.
Before we even start looking at will, we always talk about tidying up yourself. Make sure that your name is on your children's birth certificate, especially as guys. Make sure that your parents' name is on yours. Make sure your name is spelled properly on your assets. If you have a name like a hyphenated name, you will be amazed how petty the government agencies can be if somebody leaves you money in a will and your name is spelled without the hyphen. We would then have to file documents in court to reconcile. For example, Tonian, if you got $5 million and it was spelled, I think your name has a hyphen, it doesn't have a hyphen in the will, we would have to prove that TONI hyphen is the same as TONI without the hyphen. We don't want that. So what we're getting at is, before we even reach the will part, we have to be more organized about our assets. And don't worry about if you don't have a whole heap of things. If you can't, and the Bible talks about it, if you can't manage small amount of things, you're not going to manage big things.
All right.
We're going to be one second, everybody. The link, if you want to reach Richards and Richards to do the will for you, the link is in the description. So you just click on it and you complete the details, and they will do your will from there, right? Link is in the description. So I have a question though, Dennis.
Yes.
My name, let us say my name is not on my father's birth certificate.
Yes.
Can I go to court and prove by DNA that he's my father?
Yeah, man. Do them. It's called a declaration of paternity.
Right. Okay.
Yeah, man.
So everybody, if your name is not on the birth certificate, which I know a lot of you probably fall in that boat.
So you can get paternity from a dead man?
No, that was from one of the siblings, right?
What we can do without even the DNA, all you need is people who would have been around at the time of your childhood, who could speak to seeing you growing up with that person, interacting with him, being able to say, yeah, man, he used to call her his daughter. I remember when our mother was pregnant, and we would do them. It can be done, and we do it a lot. And the truth is, with many of those applications, you don't even need to attend the court.
Oh,
okay.
We have gone.
But the DNA is more conclusive, though.
DNA is what Jamaicans call button and catch. Once you have DNA, then the thing sealed.
Right.
If you don't have it, it can happen still.
All right, I have another question though. What if someone's mentioned 8 children? What does if the will was left to with only one child as a beneficiary? What the others? Is there anything the others can do?
Not if they're adults.
Not if they're adults.
No, they must get left.
Them get left.
Yeah.
So you must be around your parents when things going on, right?
To make sure you get.
So you can't be in the will.
We didn't want to say, but we never want. Let me tell you, I did a will the other day, year before last. The lady left 2 houses to one child and a glass of ice water to the other child.
Whoa.
And it sounds too harsh, but then if you're dying of cancer and someone don't even visit you, chances are you're not going to really want to leave much to them.
Okay. So it's not entitlement then?
No, it's no entitlement at all.
But it is an entitlement if there was no will.
That is what I'm so happy you put it that way.
Right.
You really want the thing to work how you want it to work, you've got to get the thing done.
Yes, because if the will was not left and they went to court then the court would have said, hey, there are 8 children. So everybody's entitled, right?
Divide by 8, yeah.
Yes, okay, got it.
That is it.
So Tonian,
Mm-hmm.
Claudia, we're hoping that you will guide us as to transitioning into the divorce presentation because time.
Oh yes, you can transition now.
Beautiful.
I guess there are some questions still, but the link is in the description, everybody. So you can complete the link. The link went in at 4:09 p.m. Can we see when they complete? All right, so Dennis, you can move into your other presentation on divorce.
Yes.
Or just a sec.
All right, so we can take a real estate question while Dennis finds his. Are you there now, Dennis?
I'm coming right there.
1 sec.
Yes.
All right, everybody. So I'm looking for that young man who asked me to help him with his bathroom. You can send me back the video. Give me a name. I'll know it's you. Send it back to me. You sent me a video in Christmas. It was crazy in Christmas. So just send it back to me.
All right, Mr. Richard, you can go ahead.
All right. It's normally a touchy thing, getting a divorce in Jamaica. People normally view it as, the end of an era. I consider it the start of, it's a new beginning. I remember Claudia quoting Amanda Gorman, you have to look at what's ahead. And when Tonian mentioned that the best approach to getting a divorce is really to figure out what's the best way to cut this cord. And the best way to cut the cord is to have as little animosity, as little warfare, the most cordial divorce you can get. because you can sort out the details afterwards. You can always work out the house. But you see, you don't want to be tied to this person if you're not really in spirit married to them, in the sense that you move, you may as well get the thing sorted out properly. Now, to get a divorce in Jamaica, you have to do your application in court. The application is made in the Supreme Court, and the process plays in 3 broad steps. You have your petition, your decree nisi, and your decree absolute, and everything is done straight on paper. You don't need to go to court once. So, and the truth is, the process used to be very, very long. Now we find it taking 9 months, sometimes less. 9 to 12 months is common, but we have seen where it takes much longer because persons don't really deal with. We send documents to somebody to sign. They take 3 months to sign it. And they send it back, and then we start moving. That 3 months add to the process. If you deal with your things quickly, you can get your divorce done in as little as 9 months. I know in some countries, like in the States, it can happen much, much faster, but it doesn't happen that fast here. And what we recommend is, until you are fully divorced, don't set a wedding date. It creates problems. You don't want to have, yeah. So, yes, please.
We're getting a break in transmission on your end.
Getting a feedback too.
All right, check your internet connection.
Yes. How's it now?
I'm hearing you, but I'm getting the red line saying that you have limited signal.
Oh. All right, we're checking on it.
Thumbs up, everybody. Thumbs up if you're, thumbs down if you're not hearing us well.
All right, we checked everything on our side. How is it now?
I'm hearing you better. Can everybody hear?
All right.
Let me just look at the comments to see what they're saying.
Right. Yes, I'm seeing the thumbs up. All right. So go ahead.
Yeah, go ahead.
Go ahead.
All right. So some key terms before we start. The petition. The petition is a document you do to start the divorce. And the petitioner is the one who is seeking to get the divorce done. And the respondent is the one that they're trying to get divorced from. The decree nisi is a kind of halfway step towards the divorce. That's the first order you'll get. And then after the nisi, you get a decree absolute. It is when you get the absolute that you're fully divorced. The last thing is the affidavit. The affidavit is really written evidence that is filed in court. And you don't normally need an affidavit unless there are children involved in the marriage, minor children. In that first step. Afterwards, when you get in your decree nisi, and so you will have to file an affidavit. Now, to be divorced, you have to satisfy 3 broad things in Jamaica. 1, you must be married for at least 2 years. You must be separated from your spouse for at least 12 months at the time when you're making the application. And your marriage must have broken down irretrievably, beyond repair. Now, this rule about the 2 years is to prevent people from being frivolous. I got a question, I think back about 2013. Lady called me the Friday evening and said that she wants a divorce. I said, when did you get married? She said, Wednesday. I said, I mean Wednesday. She got married Wednesday. I said, you can't get divorced 2 days after. It doesn't work that way. You can't, it can't happen here. You have to be married for at least 2 years. So you can petition the court if there are extenuating circumstances, like if there's violence and those things. The court will at times lower the period for you to get divorced, but they're not going to lower it beyond a year. You have to be so normally 2 years married, 12 months separated, marriage broke down badly. Now, separated don't mean you're in a different house. You can live in the same house and still be separated. Even the same room. Because the court understands that sometimes finances just don't allow you to move out and pay your own rent, and they understand. And the court even understands that people are weak. So even though you're separated, sometimes you go back for like a short while and you do married people things, and then you say, but it's not really work out. So it allows for short breaks in the separation, but those breaks can't be longer than 3 months. So if maybe you're separated from your spouse, live in the same house, Valentine's Day come around and have good memories and things go on, that won't break the separation as long as it doesn't last for more than 3 months. And basically, to kick off everything, to start everything, you need to have your marriage certificate. Now, you know some old-time marriage certificate that look like regular paper? That's not the one. The new ones, like the one that's shown here, that you get from the RGD once you apply. No, we get them for you at no additional charge. We don't charge for that service. And we also like to recommend that you have certain things out of the way before you start your divorce. It's not compulsory, but what we find is if you don't sort out those things, your divorce is going to get slowed down. So you want to have, for example, if you have children and there are custody issues that you haven't sorted out, you may want to sort it out first. It doesn't have to be a court order, you know. The parties could simply sit down and say, this is how we're going to deal with separation, with custody. This is how we're going to deal with maintenance. This is how we're going to deal with property. So when the divorce starts, those issues would have been resolved. So it's nice to get those things out of the way. And once you have those things, then you reach the first stage. The first stage is the petition. You would provide information to your attorneys, and they would plead the petition, give it to you to sign, and then they file it in court. Now, all documents filed in Jamaican courts, you must pay a stamp duty on them. And so the stamp duty is paid, and document is filed in court. And about 3 weeks after, we would collect the documents from the court with the court seal on it. And it is when you have the petition with the seal on it, they call it a true copy. It is when you have the true copy that you know are ready to serve the respondent. The respondent being the person you want to get divorced from. So, the crucial thing to remember is that you must have the document served on the respondent, but you can't serve it. Courts realize that sometimes man and woman thing get real violent, so they don't like spouses to serve other spouses. As a matter of fact, it is illegal here. A wife cannot serve a petition on a husband or vice versa, because that is when things can get really, really messy, and you don't want that. What happens is that you have to get somebody who knows the respondent and also knows that the respondent is married to you to the actual service. You can accompany them and point them out, but you have to make sure that the person doing the service is not a police officer. Police officers under the Jamaica Civil Force Act are not allowed to serve divorce papers, and they know it, but they still do it. Don't do it. It is going to slow down your divorce, and you're going to have to reserve the document. So we recommend that you don't do it. Now, the person who serves the petition would provide information to the attorneys as to where they serve it, when they serve it, and how they knew the person would be at the place. Because sometimes people, they abandon the service. No service took place. So the court wants to make sure that the person is actually aware that they are being divorced. That document now, that when they complete the information, it is a period called an affidavit. that's really evidence of service. When that service takes place, the person who gets served, the respondent, can do a couple of things. They can throw away the document and ignore it, they're still going to get divorced. Or they can complete what is called an acknowledgement service. The acknowledgement of service is part of the petition. So just tear off those pages, fill it out, and file it at court. They can do it, but they don't have to do it. Now, once all of that takes place, the clock starts ticking. And things run smoothly all the way to your full divorce unless the respondent intervenes to slow things down. And they can intervene in one of two ways. They can file a document called answer. And sometimes the answer will say, no, we did not live at Queens Avenue, Kingston 11. Queens Avenue is actually Kingston 10. It's a waste of time. The court will see it to be a waste of time, but it can slow things down. So the respondent can slow things down by filing their own documents in court in response. They can file an answer and a cross petition. Let me tell you when you normally have a cross petition. Let us say you apply for a divorce. You have young children, but you did not say anything in the divorce about maintenance of the children. Oftentimes, the other spouse will file a document saying, what about the children? Who's going to deal with lunch money and bus fare and those things? That's the cross petition, and it slows things down. The court is not going to deal with the divorce until those issues are answered. But if it's not slowed down, then about 20 days after service, your attorney will prepare documents to get your decree nisi. You will sign those documents, sign your affidavit, and the affidavit, because it's evidence, it has to be signed before. If you're in Jamaica, you sign before a justice of the peace. If you're abroad, it will be signed before a notary public. Now here's where it gets so funny. In Jamaica and other Commonwealth countries like the UK and Canada, a notary public, because we have notaries public here too, they are appointed for life. In the USA, they are not appointed for life. Typically, notaries public, for example, in the US, they have a 2-year appointment period, and then it expires, and then they have to get new certificates again. What the court wants to be sure is that the notary public that signed your document was actually a notary public at the time when you signed your document. So they have to file a certificate, which some states call it a county clerk certificate. You have to then send back your documents along with a county clerk certificate. But once we file the nisi documents in court, that's one that typically takes the longest. Once your decree nisi is granted, 6 weeks after, we file your documents for your decree absolute. And then it is granted, you're divorced. What we would do then is to, if you are here, you could either come in here in Jamaica, you come in for the document, or we send it by courier to you. If you are not here, we would FedEx your decree absolute to you at no additional cost. But that's it. That's how the process runs. So, and that's how you get your divorce. So just to recap, you file your petition court, your petition is served on the respondent, you apply for your decree nisi, you apply your decree absolute, and the process typically takes under a year. And that's it.
I will just add quickly, who can secure a divorce, get divorced in Jamaica? We have to show that as long as you're a Jamaican, Lizzie's, or Jamaica, you can petition for your divorce. Or anyone living in Jamaica for 12 months or more at the date of their petition, they can also apply at our Supreme Court to secure their divorce. So just to add that little bit.
I saw a question earlier asking about if you can't find the respondent, you're going to have a difficulty with the divorce because you have to prove service. However, if you have an idea, for example, let us say you're able to show that you, while you were married, your spouse used to read the Gleaner every Sunday, and you are aware that they have moved to a different parish, but you don't know where to find them. The court will allow you to make an application for what is called substituted service, where you can serve them by advertising in the newspaper. But that will, of course, lengthen the time to get your divorce, because then you have to make other applications in court. But typically, you would want to be able to locate the spouse, because the court likes to be able to prove service. If the spouse lives in the States, the court makes it a little bit easier to serve them. You can serve, anybody can serve that person overseas using a photograph. So they could walk with a photograph to identify who the person is, and they could serve. So it's a little bit easier. But what we tend to do is when it is time for service, we tend to give detailed explanation as to the do's and don'ts so that you don't make a mistake in service and then have to redo it.
Serenity has asked a very interesting question. What happens if your spouse divorced you while overseas in the US or wheresoever, I guess? Still divorced? Yes.
Yeah.
Just that you got married overseas, that marriage is considered a valid marriage for our purposes, yes. Right.
So you can be married in one country and divorced in another?
Most definitely.
Yeah, man. I've done divorces. Persons married in New York, now live here, and we have done the divorce here.
Or even if they live overseas.
Using the US marriage certificate.
Oh, okay.
Yeah. No,
what happens if you so if this person disappears, you don't know if they're alive or dead or what?
it's challenging, but it's not without remedy. We have had to hire investigators to locate persons.
Okay.
And we do that, I wouldn't say a lot, but we have done it from time to time. People are not as hard to locate as they think. So we have found persons. Because the truth is, you just want to be able to serve them. So let us say you locate them, you know that they work in Montego Bay. You're not going to turn up at their workplace to create an embarrassment. You just want to be able to serve them. Okay. And you could do that. For example, one way that we have done it without creating any fuss is we found out that the respondent sends money to his mother, Western Union money to her each month. So we got the court to allow us to serve the mother, because the thinking was he would bring it to her son's attention. And that was proper service.
And that was sufficient.
That was sufficient, yes.
Okay.
All right.
All right. Any other questions?
There's a question here. If the respondent, that's the person being served, refuses to sign any divorce papers, can the process continue? Most definitely. There's a myth, I would call it, where persons believe that they have to sign documents. No, as long as the petitioner, that's the person who has made the application, as long as they have the person who served the documents provide the evidence to say it was served on the respondent on this day at a particular time, then the process actually continues. That's the affidavit of service. So there is no need for anybody to sign anything for the process to continue. No.
Oftentimes it actually moves faster when they don't sign anything. Because then there's no answer or cross petition. just move.
So what happens if there are children though?
Well, if there are children under the age of 18,
Right.
the court will want proof of the arrangements for those children.
Oh, so
And
you
that,
have to find the person.
well, let me put to you this way. It's two things I want to say on it. One, if the children are under 18, you have to show the court the arrangements for their schooling, their daily maintenance, custody, all those things. And normally that is included in the affidavit that accompanies the petition. Because the court's major thing is not the two big grown adults. The court's major focus is the welfare of the children.
Oh, so the person who wants to get the divorce, if they can show that they can adequately take care of these children, even if the man is absent and you cannot find him, they can still get a divorce.
Yeah, man. There's even a line in it, in the petition, that would speak to that you could even say that we're not going to be seeking to get any maintenance from that person.
Okay.
Another thing too is, even though the law speaks to 18 as the age of majority, sometimes you may have persons getting a court order for their children for maintenance of before 18. Now, when those children pass 18, if they are in university, the other party is still legally bound to continue to maintain those children up to age 23. As long as you have a court order for maintenance before they reach 18, if when they are 18, they are in school still, you must maintain them beyond 18 up to age 23. Okay. So therefore, you will have to still speak to the children's maintenance once they are in school, and there was a court order before about maintenance.
Okay. So can we get prenups in Jamaica?
Yes. We are a little bit ahead of the US in the prenup department, because in Jamaica, you can get a prenup is really just an agreement between the parties before they get married. Jamaica allows you to have the same agreement while you are married and the same agreement after you have separated. So we have post-nup also and during nups. But what it does, and we do especially the post-nups, I like to call them, we do them frequently, because what it does is it sets out the parties' agreement, so that when you file your divorce documents, the court has that agreement before it to say the children are already sorted out. So yeah, it's allowed, but the rule about these agreements is strict. Each person has to get independent legal advice, because sometimes the parties have different levels of understanding, and they don't want one party to take advantage of the other. So you can't just say, come, we could do it with my lawyer, and both of you do it, and the same lawyer signs both. It would not be a good document.
I'm going to ask a frivolous question. If you are living together under common law, you don't need a divorce, correct?
Correct.
Yes.
You can just walk away.
Right. So you can end your cohabitation. That's what it's referred to.
End your cohabitation.
Yes. Except to say, though, that when you are in a common law relationship, all the same rights hold. So even though you can end the divorce, it doesn't end property issues.
You can still go to court and
you can still deal with the division of your property still needs to, because if you have a common law marriage, or common law relationship, sorry, and it's ended, the other party can say, I want my half, and they can take it to court for the half. So it's easier to break the relationship when you're not married, but you still have to take steps to deal with the other issues like children and maintenance.
Can they claim properties that they don't live in?
Yes, yes, but it is not as easy as the people call it the matrimonial home. The law calls it the family home. It's not as easy for the family home, which the court assumes is 50-50. With properties that you don't live in, you have to show how you contributed to getting the property. I saw a comment. It's not your assets are not necessarily at risk just because you get married. It's just that you have to be careful.
What would you call it? So if I decide to get married right now and I have assets before I got married, you would suggest a prenup?
I would suggest the prenup, but I would also suggest that those assets are very, very unlikely to be at risk with the marriage. Very unlikely.
Why is that? Because I acquired them before the marriage.
Because you acquired them before the marriage.
Okay.
So the only one that will be at risk is if you and your spouse chose to live in one of your houses,
right,
as man and wife. Then that would automatically become the family home, and then the person will be entitled to the 50-50. There is a law here called the Property Rights of Spouses Act, which governs the whole issue of the matrimonial home, the family home, and how other assets outside of the family home are divided. And your assets aren't really at risk as is generally thought. The court understands that people come to marriages with different things. And that is why that prenup thing is such a good idea if you're coming in with substantial assets. I hear American lawyers referring to a thing called gray marriages. That's marriages by people over 50. They recommend that we are a little bit more sensible than other people, because the redo, you don't really have a long redo stretch in front of you. So doing things like your prenup and those kinds of agreement, changing how you, for example, in Jamaican law, if you own a house in the name of, say, you and your daughter, that cannot be a family home. It cannot be the matrimonial home, no matter what.
Okay.
A matrimonial home must either be owned by the husband alone, the wife alone, or the husband and wife alone. Okay. If somebody else's name is on it, it can't be matrimonial home. The other person has nothing to get from that home.
Oh God, they're amazing. All right, if I may, my Serenity has been asking about annulment, and the person was more precise to say for the person with having been married for two days and wanted to get out of the marriage at that point, if annulment is an option. Okay. Again,
it depends.
We're referring to, in Jamaica, it's referred to a nullity. And there are specific reasons for you to make that application for nullity rather than for a divorce. Now, if you were mistaken as to the person to whom you got married, like you thought you were getting married to
Rachel and you married Leah.
Rachel and you married Leah, like Jacob, he certainly could have had a nullity, make an application for nullity. So there are different reasons, but having gone through the ceremony of marriage and there was no issues as to who the party was to whom you were getting married, or who the marriage officer was and whether or not he or she was a marriage officer, and you were over the age of 18, you will have to make your application for a dissolution or a divorce, not a nullity or annulment. It works a little different in our jurisdiction as against the US side.
There's one annulment that I'm doing now, where at the time of the marriage, the man was married to someone else.
Right.
She didn't know. I did one about 6 years ago. The man actually had 3 wives simultaneously here. None of them knew that he had, I don't know why but he had a number of wives. Those wives, those persons who went through the ceremony of marriage can get an annulment, because they were under the mistaken belief that they were marrying
A single
person.
Yes.
Another way you can get an annulment in Jamaica is under our law, only persons of opposite gender can get married. So if at the time of marriage you were tricked as to the gender of your spouse, let's say somebody mistakenly like marry RuPaul thinking is a woman, then you could get an annulment without having to wait the period.
What if the marriage was consummated?
We don't really have consummation as an issue. I have done divorces where the persons have never ever slept together.
But it's still a divorce, not an annulment?
Yes,
Divorce.
still a divorce. They still have to go through. The court doesn't care if you decide to be celibate after marriage.
All right, so everybody, the link is, can everybody see the link? Link is in the description. If you want to get a divorce or if you want to do a will, well, the main takeaway I get from this with the will, if it is as a parent, a grandparent, you want only ex-children to get your real property or whatever other assets you have, then you need to do a will. Because if you don't do a will, then the court will go according to law, which is that everybody is entitled. All right?
Mr. Richards, is there anything I cannot leave in a will?
Yes. You can't leave anything that's illegal. So if let's say you had weapons of mass destruction, you couldn't leave those.
I can't leave my guns, no?
You can leave what?
My guns.
Guns.
No,
You can.
you can.
I can.
Can I answer that quickly, Tony? You can, but in our jurisdiction, the person to whom you leave it must also have a license.
Oh, okay.
Yes, it must be trained.
And they
yes.
have to be trained.
No, I can't have a family chest of guns as family heirlooms and leave it to somebody in the family. No.
Not
Only if they are also licensed. But what we find, and I don't want to prolong it, but as Jamaicans start acquiring more and more assets, we're finding them being more sophisticated, not just in doing a will, but in how they do will. Richer persons set up what they call secret trusts to minimize the amount of taxes they pay. So you may find in a will a line that says, all my other assets I give to my wife according to the letter I've already shared with my lawyers. It sounds vague because the intention is for it to be vague. Because remember, when you file your will and the probate at the tax office, they're going to tax your estate. So what? Let us say you own the Mona Lisa. The Mona Lisa is not cheap. The tax on the Mona Lisa is not going to be cheap. So you don't want to mention in the will that you own Mona Lisa. You put that in a letter.
In a letter.
And you give that with your attorney, who will know that Tony must get the Mona Lisa.
Right. Okay.
So that is never mentioned in your will. So it's not assessed. The tax would not be mentioned. Would not.
Yeah. You can't do that with property because the property has to be transferred. Correct.
Exactly. So only the properties like your share certificate and those things that have a title.
Yeah,
even what we've found, and it happens frequently, assets such as motor vehicle, which can be wasting assets, we can move quickly to get those things transferred even before the will is probated.
Right.
Because the court understands that you don't want those assets to diminish.
Those liabilities.
Yes, if you own say a mine, and those things, you are a business, you need to move quickly to get those things sorted out. So what you'll find as Jamaicans get more assets, you find persons will have a regular executor named in their will and then a business executor. The business executor would be somebody you know who would step in the shoes and run your business, make those business decisions until the estate is settled. So for persons with businesses, you have to think about having a business executor who will know how to deal with your returns and your taxes and staff and decisions and calling the board meetings and those things. So it's something to think about.
All right, everybody. So the form is in the link if you need it to get a divorce or for Richards and Richards to do your will and have it, what was it? What did you say? Stamp at the stamp office?
Yes.
Recorded at the stamp office.
Yes.
That was the word you used, recorded?
At the Islands Record Office.
At the island, sorry, the Island Records Office.
Yes.
And so, we try to let the professionals do what they do best, because the worst thing you want to do, is do up that will, and then it is problematic in the courts, right? So you want to get it done properly. So the link is there. We're trying to we can take some real estate questions now.
Yes.
Mr. Richards, can the executor be your law firm?
Yes, ma'am.
Okay.
Well, the executor can be the firm. Executor could be Veritas, or it could be. So, in other words, a company can't be an executor unless they have special licenses from the Ministry of Justice, which Veritas has. Otherwise, it has to be an individual.
Okay. So your other company is Veritas.
Veritas could
have that license to be the executor.
Yes, or an individual could be the executor.
Okay, all right. So everybody, so we did wills this week, but we are also going to be looking at trusts. So we will, Richards and Richards will be scheduled to come back on and talk to us about how we can, if you don't want to go the will route, you can go trusts, right? Okay. Which is more where I would prefer to go as opposed to will, because I want to have some level of control over what happens, right? Mm-hmm. So everybody is there. We still have some minutes, but for us, we seem to have lost our ability to see the questions. So Lejon is saying thank you. Persons are saying it's very informative. We seem to be losing our.
You can look here as well.
I need to know that. Looking forward to the session on trust. Yes, thank you. So Richards and Richards will come back on and do that.
Do we know when they're coming on as yet?
You can also put in the comments, people, anything that you want us to discuss or other professionals that you think would be helpful for things that you want to know. You can put that in the comment section, because we do go through the comments and look at them. That is how I know that Mr. Samuels is going to buy me the banks. All right. I'm saying Mr. Samuels. It could be a Mrs. Samuels or Miss Samuels as well. I don't know. Are you seeing any of the comments, Tony?
Yeah, they're here.
Shereen, can you see the comments?
Yes. I can, yes. And I'm so sorry that we missed so many questions, but we ask for your forgiveness. Repost them if you can. We have 7 minutes to go. Sure. If we have not addressed them.
Answer the questions if you can see them, because for some reason our screen is blank.
Right, just 1
second. Continue answering the divorce or will questions.
Here's some of them. Maxine, this was very informative and interesting. Thank you, Mr. and Mrs. Richards. Have a lovely evening. That was from Maxine.
It was our pleasure. Our pleasure.
Absolute pleasure. Luke is in JA. Where do you normally conduct your presentations? Church, workplace, yes. Everywhere, anywhere.
We do a lot of church presentations. Yeah. We have gone to hospitals to talk to persons, schools.
Yes.
We don't charge for presentations because what we find, if people know, they make better decisions.
Absolutely.
So, yeah, man. And Mr. Chris Hill had asked earlier if a will is the same as a trust.
Yes, somebody just asked.
No. A will is a document that only takes effect after death. A trust can take effect right now. And the thing with a trust is that the person who is setting up the trust, that person is called a settler. That person can start having influence over the assets while they're alive. So you could set up the trust, pass your assets over to be owned by the trust, and then you could set up a board of trustees and to have control over how your assets are dealt with and how the income from it is dealt with. Normally, people view trust as just a rich person thing, but we're seeing persons now doing trust. Let's say you have a child that has Down syndrome, and you can't leave your assets to that child. You're going to have to set up a trust of some sort to make sure that you can take that child will be taken care of when you're gone. So a trust is not something just for rich people. It's something that everybody should look at doing if they have any assets.
All right, two quick questions, maybe our last. John Maris asked if 3 persons own real estate jointly and 2 decide to relinquish their ownership without financial compensation. All right, does transfer tax and so on apply? The first thing is the transaction is referred to as a transfer by way of gift. So no money is passed hand as between the parties. The 2 is given to the 1. And yes, transfer tax is likely to be payable as far as the portion being transferred. Transfer tax is 2% of the value of the property that is being transferred. So let us say it is considered that the 3 hold equally, that's 33 1/3 each, and they would then be transferring 66.6.
They're transferring 2/3.
So they're transferring 2/3, which means that you would then pay 2% on the 2/3 value. Yeah. Definitely. All right, so that's one. And the next very quick one.
Claudius Jones was asking the cost to do a will. It's $100 or the Jamaican equivalent of $100.
All right. So, and My Serenity asks, what happens if you have a will overseas? Where is it probated? You can, and the person passes. You definitely can probate it in the jurisdiction where it is. So if it's in the US, UK, Canada, it can be probated there. And let us say it covers assets that are in Jamaica, which it can, then you would send that probated will, a certified copy from the court that issued it, would then be sent to Jamaica for our court to do what we call, the process is called resealing, which is usually much quicker than the actual probate process itself. And yeah. Oh, okay. Where's your office located? We're at 18 Queens Avenue in Kingston 10, Jamaica. We will type it in the comments in a minute. I believe the information sheet that Claudia gave you in a link also has it, but it's coming up shortly. What's the cost to do a divorce or charges?
$650 or the Jamaican dollar equivalent.
Covering the charges.
That covers the cost of stamping, when
FedEx.
we FedEx the document to you, the absolute, that is editorial. That's the only thing you do.
Yeah.
And if you're interested and you don't have the 650, we have payment plans.
Right, and it's in the form that we that link that we gave you, everybody. If you complete it, then you will get back the information.
Right. So because it also asks, can you leave assets to charity church?
Yes.
Most definitely. Just make sure that the person to whom it is being left or your assets are being left to, that it's clear as to who it is. Once that's clear, it's not a problem at all. So Veronica Gill is asking about a power of attorney. I didn't get what the question.
Somebody's asking if the spouse can have a claim in equity.
Oh yes, I saw where I believe Lucas brought that up. I didn't get to address it. The question was very precise from John, where he said not in the home but in other assets. It's very difficult for them to have a claim in the other assets if they did not make a contribution towards its acquisition. So equity would also fail them, right? But I mean, let me tell you, we can't stop persons from having their day in court. So if somebody truly believes that they have a chance at getting something, they will definitely put their claim in court, and then the person who has to defend will have to properly defend it to say, no, you don't have any rights to this. And then that drags on for a good, I don't know, 4 or 5 years. So hopefully they will live to see the end of it. So yeah, that's it.
All right. Any more questions? We are up on the time.
About 2 wills.
2 wills? Where? Can you have 2 sets of wills, i.e. assets for abroad and assets for Jamaica?
Yeah, you can. I don't recommend it though, but you can.
You see, it's your will. The will that you make often speaks to it being your last will and testament. And when you have more than one will, I believe they give rise to contention, even though you want to make sure that the state or the country in which you have the countries in which you have your different assets, that they are properly dealt with in accordance with that jurisdiction, the law in that jurisdiction, and so on. But it is best, I would recommend, that persons seek that clarity as well from the state or the country in which they reside. If overseas, we are sure that assets, a will done in Jamaica can cover assets in Jamaica. And I've also seen where clients do their wills to cover assets
here,
overseas as well, yeah, both here and overseas. So we have seen that. And just bear in mind that typically a will is your last word. Your last will and testament is your last word. So you want to avoid conflict, but it's something that you can verify.
It's not good to have multiple wills.
No, not at all.
What if you have insurance policies and you have a beneficiary insurance policy, and then the person left a will giving the money to somebody else, the insurance policy to somebody else? Which one would supersede?
The insurance policy.
The insurance policy would supersede.
That gift in the will fail. So it doesn't affect the validity of the will in which that insurance proceeds was included. Mm-hmm. But the gift will not pass to whomever they have in the will. It will pass, the insurance policy proceeds will go to the beneficiary that is duly nominated on the policy. Yes. That's it.
Same thing with bank accounts. We see people having joint accounts and leaving the money in their will. Joint account money cannot be left in a will. Once you pass, the money is automatically owned by the person who is the remaining person.
The survivor, so
the survivors. And you should leave somebody on your joint account, because normally when death happens, we have these expenses that we have to pay and all of that. So and the bank is not going to give anybody who turns up that money.
No.
Your name alone is on that bank account. The bank is going to give, they're not going to get it.
And it ends up being tied up for years.
It's tied up.
And it becomes the government money.
Becomes the government money.
You don't really need
and everybody warring over the money too.
Yeah.
So you want to put somebody who you can trust. You have adult children, just add their names to your bank account. It doesn't cost you any money.
Right.
Unless they take out the money.
I don't know if this can be a last question. Daniel Grant asked, if your mom has more than one. Oh, there's an answer. It's equally, Daniel. It doesn't matter who took care. However, you can make a claim for the medical bills. So if you have a sick parent and you're the one spending to take care of that parent, the law allows you to claim back the reasonable expenses. However, which is unfortunate, it normally is only for the 12 months up to when the parent died.
Right.
So it couldn't be medical expenses going back years. It would normally be for the 12 months immediately before death.
All right, everybody. So we are out of time. We're adding back the Zoom link. We go on to Zoom now at 5 o'clock. Those of you who want to join us on Zoom, we're still studying the book, Think and Grow Rich. So you can join us on Zoom. I want to thank Mr. and Mrs. Richards.
It was our pleasure.
Time out of your Sunday today. Enough respect, enough big up, right? I know all my viewers, 100, how much I know? Something, 182.
Yes.
Thank you, everybody, for coming on a Sunday and listening. Remember, the links are there. If you want the divorce, get it now, move on with your life. Want to leave a will, tidy it up. We have found that people leaving themselves family property, but that is just dead left. If you don't leave it to anybody, nobody in charge, it's just dead left and it is there and the family not prospering, right? So don't leave things untidy. Tidy it up. You're the adult now, you're in charge, so you tidy it up. All right. Thank you, everybody, and I'll see you over on Zoom.
Bye, everyone.
Bye.
Bye.